thank Assignment Judge Deborah Silverman Katz for allowing us to use her courtroom here today. It's got much more room than any of the other courtrooms had, so that we could accommodate what we were expecting to be a large crowd of people. We're here today for a very limited purpose. First appearance. Purpose is to, number one, inform the defendant of the charges against him. Number two, explain to him his basic rights as a defendant in a criminal case here in New Jersey, and in this instance also to deal at least on a preliminary basis with bail. This indictment charges in count one that the defendant committed purposeful or knowing murder, and then count two is a second degree, it's first degree charge. Count two is second degree endangering the welfare of the child. Now, Mr. Pacino, do you and your client have copies of the indictment?
Yes, Your Honor, I have 2 copies here.
As to your rights, sir, number one, you have the right to remain silent, which means nobody can force you to talk about anything about this case. What goes along with the right to remain silent, however, is that anything you do say can be used against you later on. You further have a right to be represented by an attorney. You can hire your own, which you have done here. If at some point you believe you do not have the resources to be able to have a private attorney, you have the right to apply for a public defender to be appointed to represent you. You have a right to a trial before a jury. You also have the right under New Jersey rules to apply for pretrial intervention as well. Do you understand these rights, sir? That's a yes response. With respect to bail, I will hear first from the state, and then I will hear from the defense, and you can be seated if you'd like, sir.
Thank you.
Thank you, Your Honor. Judge, it's my understanding that bail has initially been set at $1 million cash or bond. It's the state's application that Your Honor maintain the bail at that present level for the following reasons. In reviewing the bail factors, excuse me, the first factor is with regard to the seriousness of the crime, the likelihood of conviction, and the potential sentence. With regard to the seriousness of the crime, obviously there is no crime more serious than murder for causing the death of another human being, much less the death of a 3-year-old child. It's a violation of the most sacred trust, the trust between a child and their parent, between a little boy and his father. The minimum sentence for that crime, should the defendant be convicted, is 30 years in prison. The maximum sentence for that crime is, as it should be, life imprisonment. With regard to the likelihood of conviction in this case, the investigation of the death of Brendan Creato was lengthy. It involved multiple local, state, and federal agencies. The results of this investigation were presented directly to a grand jury, which yesterday returned an indictment charging this defendant with murder and endangering the welfare of his own child. Accordingly, probable cause has already been found by an independent body. The investigation showed that on the morning of Tuesday, October 13, 2015, at 6:07 a.m., the defendant called 911 and reported his son missing from his apartment in Haddon Township. While this call may or may not be noteworthy for the defendant's flat affect and tone throughout, it is definitely significant for his statement to the dispatcher that the apartment door was locked, that it had been locked the night before. It is further significant because the defendant is also heard telling his mother that both the exterior door and the hall door to his apartment were locked the night before. At 8:43 that morning, Brendan was found by a K-9 unit partially submerged in a stream that feeds into Cooper River in Haddon Township. He was wearing pajamas and socks. The first conclusion of note during this investigation was that Brendan Creato did not, under any circumstances, walk to the location where he was found, which, if you follow the path tracked by the K-9 unit that located him, was approximately 3/4 of a mile from the defendant's apartment. In order to reach this location, one must walk on a dirt path through a wooded area, across a large grassy field, and down a steep hill, again on a dirt path, to where the stream is located. It is muddy down there and it is damp down there. Brendan's socks were perfectly clean, so we know with absolute certainty that he did not get to that location under his own power. Moreover, it's extremely dark in those woods at night. So dark, in fact, that members of the prosecutor's office, some of the detectives who are unfamiliar with the area, were unable to navigate that path to the stream in the dark. They had to use flashlights to get there. And this is significant for 2 reasons, that darkness. First, Every person who participated in caring for Brendan, including this defendant, Brendan's mother, Samantha, both his grandmothers and his aunt, all stated that Brendan, like many 3-year-olds, was very afraid of the dark. In fact, one indicated that Brendan wouldn't even go to the bathroom unless someone turned the light on for him first. Even the defendant, in his statement to police, said, quote, "I don't see him just walking out the door and just leaving and going all the way down to Cooper. That sounds so unlikely to me. How he could end up at Cooper River is blowing my mind." The defendant also informed police that Brendan had never before left his apartment by himself. He never once left his mother's house by himself. He never once left his grandparents' house by himself. The second reason that these dark woods are significant to the investigation is because, according to this defendant, that location, the location where his son was found, is his favorite place in Haddon Township. He told the police and others that he goes there often, and at one point referred to that location as spiritual for him. We know that the defendant was there as recently as Sunday, October 11th in the evening in the company of his girlfriend, because he used his cell phone to take a photograph at that location. In speaking with his girlfriend, she advised police that in the 4 months she had been seeing the defendant, they went to that area, that location, at least 20 or 30 times. Clearly, the defendant is well familiar with the area where his son had been placed and would have been able to easily navigate it in the dark. This investigation further revealed that it is implausible that there was an intruder into the apartment. There is no sign of forced entry on either door. Although the defendant later told homicide detectives he wasn't sure if the doors were locked, he told the 911 operator the doors were locked. He told his mother the doors were locked. And he told the first officers from Haddon Township on the scene that responded to his call, he also told them that his apartment doors were locked. In addition, the apartment that he lived in was quite small. According to the defendant, Brendan slept on a love seat in the main room, which consisted of a small kitchen living room type area. The defendant slept in the adjacent single bedroom. The distance between the door of the defendant's bedroom, where he slept alone in a full-size bed, and the love seat where he put his son to bed with just a blanket and a pillow, measured at 107 inches. That's less than 9 feet. His son was less than 9 feet away from his door. Surely the defendant would have heard an intruder just outside his bedroom. There was no one in the apartment that night but Brendan and his father. In addition, the defendant has advised the police that day in his statement that there was nothing in his apartment that was disturbed, that was different than it had been from the night before. He also advised police that there was nothing missing from the apartment, except, of course, his son. With regard to the cause of Brendan Creato's death, Camden County Medical Examiner Dr. Gerald Feigen conducted a post-mortem examination on the same morning Brendan was found, just a little more than 2 hours later. There was no evidence of injury that would cause death. There was no evidence of disease that would cause death. There was no indication whatsoever that Brendan had been assaulted physically or sexually. A complete skeletal survey revealed no evidence of bone fractures, recent or otherwise. Examination of Brendan's brain, however, revealed a moderate flattening of the gyri, which indicates that he had been deprived of oxygen for some period of time. It was widely reported that the medical examiner initially ruled Brendan's death as undetermined. This is incorrect. It was actually ruled pending, as in pending further investigation, including but not limited to toxicology and microscopic studies, which at that time had not yet been conducted. Dr. Feigen called in 2 colleagues to examine Brendan. The first of those subsequent examinations was conducted on Thursday, October 15th by Dr. Charles Siebert, who was also a medical examiner in Camden, Salem, and Gloucester counties. At that time, the only change noted from the initial postmortem examination was an area of contusion in the region of Brendan's right clavicle up by his collarbone near his neck. Subsequent microscopic examination of that bruise revealed no evidence of healing whatsoever, indicating that it occurred just before Brendan died. The third post-mortem review, which occurred on Friday, October the 16th, was conducted by Dr. Andrew Falzon, who currently is the acting medical examiner for the state of New Jersey. There were no new findings in that third autopsy. Dr. Falzon noted, however, that included in the differential diagnosis would be, quote, smothering, which would leave a paucity of anatomic findings, end quote, and, quote, drowning, which is essentially a diagnosis of exclusion, end quote. Toxicology tests were returned and were negative. Dr. Feigen reviewed all the medical records from Brendan's pediatrician. He conducted extensive microscopic examinations of the lungs, the heart, the liver, the spleen, the pancreas, the adrenals, the kidneys, the brain, the meninges, the thyroid, the thymus, and the trachea. These slides, the microscopic slides, were also reviewed by Dr. Charles Siebert. Again, there was no evidence of injury and no evidence of disease microscopically. On December 15, 2015, Dr. Feigen amended his findings with regard to both the cause and manner of Brendan Creato's death. It was his opinion was as follows. Brendan Link Creato died of homicidal violence of undetermined etiology. This is a diagnosis of exclusion and includes, but is not limited to, drowning, asphyxia, blunt neck trauma, which includes ligature and/or manual strangulation. A thorough examination of the body, which included complete autopsy with the examination of the organs of the torso, neck, and head, examination of the soft tissues of extremities, spinal cord, face, neck, both anterior and posterior, cranial sinuses, complete skeletal survey, complete histologic examination, that's the microscopics, of all organs, and complete toxicologic exam was performed and revealed no cause of death. The scene showed a child wearing clean socks that could not have been worn from home and walked into the location in the water where he was found. This shows that the decedent had been placed in this location and had not gone there under his own power. Based on all of these findings, it is clear that the cause of death by reason of exclusion is homicidal violence of undetermined etiology, and the manner of death is ruled homicide. Dr. Siebert also issued an opinion in the case. He indicated, his report reads, "It is my opinion that while no obvious anatomic cause of death can be found, this is circumstantially not a natural death. As such, the cause of death in this case is most appropriately homicidal violence, not otherwise specified." And he too ruled homicide. Those were the findings of the medical examiners and the results of the autopsies. Any time that a child is killed, the first thing that people want to know, including the homicide detectives, of course, is why. Why would someone kill their own child? There must be a reason for someone to do something like that. What was learned during this investigation was that in the middle of June 2015, the defendant began seeing a 17-year-old female that he met on Tinder, which I believe is a dating application that's based on geographical location. On their second date, the defendant told the juvenile about his 3-year-old son. Despite her strong and outspoken dislike of children, the defendant entered an intense romantic relationship with her that went through the summer of 2015. Detectives conducted a forensic examination of the defendant's cell phone. They discovered that the defendant and his girlfriend exchanged 9,487 texts from June until the day Brendan died. The relationship began to have problems in September of 2015 when the juvenile left to go to New York to attend college. Because at that point, she and the defendant could only see each other on weekends. Because the defendant shared joint custody of Brendan with Brendan's mother, he had Brendan every other weekend. The girlfriend found this unacceptable and began to make known her disdain for the fact that the defendant still communicated with Brendan's mother and spent time with Brendan rather than her. She blogged about it, she texted him about it, and some of it is unbelievable. She repeatedly threatened to break up with the defendant, and he repeatedly begged her not to. On October 6th, 2015, the Tuesday before Columbus Day weekend, exactly 1 week before Brendan would be found in that creek, the defendant's juvenile girlfriend wanted to come see him, but that was his weekend to have Brendan, and she was not happy about that. On that day, they exchanged 578 texts. The girlfriend threatened not to come down. She said she wouldn't be able to see the defendant for months because she was going to make plans every other weekend with her family, just like he had with his family. She said if she did show up in Haddon Township, it would only be to end their relationship and get her Christmas lights. Despite her teenage threats, she did end up traveling from New York to Haddon Township that Friday, and Brendan was at the apartment that Friday night. According to the defendant, he and his girlfriend fought that night over the fact that Brendan was there. The defendant told police that she issued an ultimatum to him. Brendan spent the next day and night with his grandmother, and the rest of the weekend went smoothly between the defendant and his girlfriend. By the time the girlfriend boarded the train to return to New York on Monday morning, which was Columbus Day, she and the defendant had decided to continue giving their relationship a try, despite her disdain for his child. All seemed well. All was not well with the defendant, though. The investigation revealed that in the preceding weeks leading up to Columbus Day, the defendant learned that his girlfriend was talking to a guy she went to college with, and he was jealous. He was so jealous, in fact, that he used one of his girlfriend's social media accounts to pose as his girlfriend and message this guy and say, "I don't want you to talk to me anymore." Now, based on the defendant's phone records, we know that on Monday, the 12th, again Columbus Day, the defendant took his girlfriend to the train station and she returned to school. There is no question in anyone's mind that his girlfriend was in fact in New York from Monday morning until she returned to Haddon Township to speak with police Tuesday late in the afternoon. So she simply was not in the area at the time Brendan disappeared. We do know that the defendant called her, though. He called her 8 times between 8 and 8:15 that night after she returned to school. They spoke for approximately 4 minutes at 8:15 p.m. According to the defendant, at that time, the girlfriend told him she was going to go to bed early because she had a test she needed to take the next day and she was tired. After they said their good nights, he texted her a few more messages, kind messages, telling her she was beautiful, things of that nature, and she never answered any of them. At approximately 8:30 p.m., the defendant's sister and his mother brought Brendan from their house over to his apartment. Brendan was freshly bathed. He was in his pajamas and slippers and all ready for bed. His mother and sister left at approximately 8:50 p.m. that evening, leaving the defendant alone with his son. Now, according to the defendant's statement, he read some stories to his son, Brendan went to bed on the love seat at 9:30, and he himself went to bed at 10, where he slept, sleeping through the night, waking up at 6 o'clock in the morning to find his son missing from his apartment. That was his story. The forensic examination of his phone, however, tells a much different story. According to the forensic examination, the defendant used his phone to get into his girlfriend's, one of her social media accounts. It's called a Snapchat account. He saw that she received a message, or snap, I believe they're called, from a guy at school, the same guy that he was already jealous of and already worried about. He saw that on using his telephone at 9:02 p.m. He also used his phone to access her Facebook account that night. He then tried to call his girlfriend 3 times in between 9:54 and 10:07 p.m. According to the phone records, she did not answer any of his calls. The last time the defendant's phone accessed an article on his girlfriend's Snapchat account was at 1:37 a.m. on what would be now Tuesday, October 13th. So it would seem that he did not, as he told detectives, go to bed at 10 o'clock the night before. When the detectives were speaking with the defendant about this evening, he admitted to them, he described himself as being jealous that night. He said he was suspicious because he was suspicious of his girlfriend because she was going to bed so early. He didn't believe her. He said he was having a lot of anxiety about her talking to that guy, the person she attends school with. And he described his own state of mind that Monday night as jealous and paranoid that he was going to lose his girlfriend, who he was so clearly in love with. And there, sleeping in the very next room, was the primary source of his girlfriend's hateful discontent with their relationship. Just a little more than 4 hours after the defendant last accessed his girlfriend's Snapchat account, he called 911 and reported his son missing. This is obviously a circumstantial case, Your Honor, but the circumstances of it are quite compelling, and I submit, therefore, that the likelihood of conviction in this case is quite strong. With regard to the other bail factors, Your Honor, the only one I think that I wanted to mention in this case would be factor number 8, and that would be any other factors bearing on the risk of a failure to appear. In this case, Your Honor, the defendant's girlfriend, who I have not mentioned my name because she was a juvenile at the time this occurred, they are still together. They are still a couple. In fact, she was at his parents' house in Haddon Township yesterday. She has significant out-of-state contacts. She was born and raised in Pennsylvania. She currently attends school in New York. She and her family have not been cooperative during the course of this investigation with law enforcement authorities. So my concern is that there's a significant risk that he will fail to appear because of his continued relationship with the woman and because of all of her out-of-state contacts. I think that makes him a flight risk. And Your Honor, if I may, the last thing that I wanted to say with regard to this case, because obviously we're in a very large courtroom and it's getting a lot of attention, there are rules of professional conduct that govern how attorneys must behave during the course of a trial like this. So I just wanted to say publicly that the prosecutor's office will not be making any statements regarding this case that are not made in open court, like the ones I just made. And with that, Judge, I would ask that you keep bail as it is, and I thank you.
If I may, Your Honor.
Yes.
I feel compelled to address specifically those things that Ms. Shaw addressed regarding the likelihood of conviction. I trust the court has seen far, far more cases than I have, but very humbly, to say that this case is circumstantial but compelling, I couldn't disagree more. What Ms. Shaw would have you believe is that Deidre Creato is smart enough to somehow smother or drown or strangle his son in a way that is leaving the remains where they can only determine a cause of death by exclusion, but at the same time, during a statement to police the day that his son is found missing and ultimately found dead, says things like, there was a huge problem between me and my girlfriend, and I was so paranoid and anxious that night. It makes no sense. Wouldn't he not tell the police about the problems with his girlfriend, about the problems, as Ms. Shaw puts it, because of his son? Any issue that he has, just listening fairly and reasonably to what Ms. Shaw has to say about his girlfriend, don't come from his son. They come from the fact that she's far away and maybe she has a new boyfriend. What is most compelling to me about what she said is, he says he went to bed at 10 o'clock, but he has these snaps or texts from 9 to 10:07. I guess we can call it the 7 minutes. And then the last one is at 1:37 in the morning. I think it's remarkably absent that between 10:07 and 1:37, the Shaw doesn't mention any, because I don't know what anybody else does with a cell phone, but when mine goes off in the middle of the night, I'll typically take it, go, and I'll put it back. And nothing that Ms. Shaw suggests anything more than that. I don't want to close to the court. I understand that there is a lot more that we have to get through, but because Ms. Shaw chose to address specifically the likelihood of conviction in making her determination about what the court should consider about bail, I think it's really important to address it. The same way, Your Honor, that, again, we're going to believe DJ Creato when he tells the 911 operator the doors were locked. She doesn't believe him when he says in his lengthy statement to police that day, I did not kill my son. I understand the nature of prosecution is picking apart and believing what is most convenient toward building the case, but it's very, very important, I think, for the court to know in making its determination about bail that the morning that the boy was found, DJ Creato spent the entire day answering the question of investigators. I was there, Your Honor, outside, waiting to see my client. He said, I don't need a lawyer. I want to speak to the investigators all day. Bail, ultimately, Your Honor, I would say comes down to, and I realize that there are all sorts of codified factors, but bail ultimately comes down to two real things that I think the court has to consider. First, the likelihood of the defendant to appear. Ms. Shaw is talking about his girlfriend's out-of-state contacts as far away as Northeast Philadelphia and Pennsylvania and New York City. Not Albuquerque, not Nicaragua, literally around the corner. But frankly, Your Honor, that could all be met with, at the end of the day, an ankle monitor, which can be arranged. More importantly is Mr. Creato's danger, I would say, to the community when he has such horrific, horrendous, serious, heinous charges. But the truth of the matter is there is nothing to suggest he is a danger to anyone else. He has no prior record to speak of as far as convictions go. And here he is at 22 years old, knowing for 3 months that this investigation is going on. He hasn't gone anywhere. He hasn't done anything. No, Ms. Shaw doesn't say, and we have a phone intercept where he finally admitted what he did. Or after 9 hours of being questioned by homicide detectives, he finally said, you got it. Or they came up with some enormous inconsistency. So now you have a man who, look, he stands accused. It's very serious. I understand that. But it's just an accusation. He stands accused of as bad of a crime as it gets, and it's awful. But nothing other than this circumstantial case Ms. Shaw has laid out before the court suggests he's going to be convicted. In a word, Your Honor, weak. It's weak. And for purposes of the bail hearing, I think it's important for the court to consider that it's weak. The guidelines, I understand, suggest bail between $250,000 and $1 million, and I understand the bail is at $1 million. But we don't have a guy who has prior gun convictions or prior drug convictions or has a confession, a statement, eyewitnesses, video camera, anything like that. And with all of that, Your Honor, I think the court has to say, well, what is this bail range for? What is the $1 million bail for? Who is that for? And what is a $250,000 bail for? Who is that for? When you have a person who has the support of his family, his parents, and other supporters are here for him today, when you have somebody who has no criminal conviction in his record, and you have, again, Your Honor, I I say weak. When you have a weak circumstantial case against that person, does that person have a reason to flee? Does that person have a reason to stay and clear his name? At the end of the day, Your Honor, Ms. Shaw said at the beginning of when she addressed the court, this is as bad as it gets. He isn't accused of killing another adult or a man or someone who he had some problem with. He's accused of killing a beautiful little boy. And when you have just such a heinous allegation thrown at you, frankly, it's not enough to be found not guilty. It's not enough to say, I didn't do it. You have to be able to walk the streets and to have people look at you, and you have to clear your name. And that's what Mr. Creato has to do here. So in every single way, there is reason for him to come into court to clear his name, and there is nothing to suggest that he's a danger to anybody else. I'd ask the court to put the bail at the absolute bottom of the guidelines at $250,000, and whatever conditions are appropriate, that he doesn't leave the state to go all the way to Northeast Philadelphia, 16 miles away, or up to Manhattan, or wherever else he may go, or an ankle monitor if that's what makes the court feel more comfortable. I think all of the issues that could occur, that could be a problem for him on bail, can be addressed with that ankle monitor, and the court should put it at the lowest end of the guidelines. I appreciate it. Thank you, Your Honor.
Judge, can I be here just briefly?
Yes.
First of all, the defendant, based on the crimes he's been indicted for, is not eligible to be monitored electronically while he's out on bail. Secondly, counsel's argument with regard to the defendant's danger or lack of danger that he presents to the community, likewise, is not relevant, as it's not one of the factors that is permitted to be considered by the court in setting bail. And lastly, Your Honor, I would ask that if the court is considering lowering bail and it appears that the defendant is going to be able to post bail or bond, I would ask for certain conditions, and that would be that he surrender his passport, that he be ordered to stay in the state of New Jersey, and that he be ordered to have no contact with his son's family on the maternal side, no contact whatsoever. Thank you.
Well, we would have no problem with any of those conditions.
In New Jersey, at least under our current law, the only purpose of bail is to ensure the defendant's appearance in court. The court is not permitted to set a bail for the purpose of addressing the danger to the community issue. Factors in setting bail: number one, seriousness of the crime charge, apparent likelihood of conviction, and the extent of the punishment. Those are all part of one factor. This is the most serious of our crimes: first degree purposeful or knowing murder. Extent of the punishment, also the most serious. Minimum sentence upon conviction of count one, 30 years in prison, 30 years without parole. Maximum sentence, life in prison, roughly 67 years without parole. With respect to the main ground of argument between the parties at this point in the case about the apparent likelihood of conviction, the state acknowledges its case is circumstantial. As juries are told during trial, circumstantial evidence is as valuable as direct evidence. It can lead both to a finding of guilt or a finding of not guilty as well. A lot of the argument on the defense side focused on issues connecting with the state's allegations relating to motive. Ultimately, the state's not required to prove motive. It may well present that evidence to the jury in connection with his arguments, but it's not required to prove motive in a case such as this. So to the extent that there's some question about the apparent likelihood of a jury concluding that the state's motive theory is compelling, that doesn't necessarily affect the question of whether the other allegations that the state has made and the other conclusions that the state has reached based on its investigation, the compelling nature of those as well. And I do find that they do constitute, in a case given that it is circumstantial, that is a factor that does weigh in favor of a significant bail. On the other side of the fence, the defendant has absolutely no prior criminal record. On the factor, also as the defense notes, the defendant has been involved in this investigation since its outset. He has never left. There's been no report from the prosecutor that he was ever unavailable, ever attempted to flee, ever indicated that he intended to do that. On the factor with respect to the girlfriend's out-of-state contacts and her families as well, I don't find that particularly persuasive either. My conclusion ultimately is that this is not a case where the top of the range bail is justified, weighing all of those factors. But I do not believe that the low end of the range is justified either. Bail is set at $750,000, cash or bond. If the defendant posts bail, he must forfeit, surrender, his passport. He is to have no contact with the child's mother or her family. And he is not permitted to leave the state of New Jersey absent further order of the court. That concludes today's proceedings.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome back.